to move to item 12, and let me make sure that I have the language for that item. Okay, item 12.
Public hearing, appeal of zoning examiner special exception land use decision TEP ENT 1025-00021 TEP Vine Substation, Vine Avenue R2.
City Manager's Communication number 159 dated June 9th is received into and made part of the record. Ladies and gentlemen, this is the time and place legally advertised for a public hearing on an appeal of the zoning examiner's decision in case number TP-ENT-1025-00021, the TEP Vine Substation. The city attorney will first summarize the issues presented in this case.
Honorable Mayor, members of council, thank you very much. This appeal of the zoning examiner's special exception, they granted the relief requested by the applicant, Tucson Electric Power, for the Vine substation, is to resolve the issues presented by the appellant. The appellants are Underground Coalition and Underground Arizona. Those appellants have requested the mayor and council to decide whether or not the zoning examiner correctly reached the correct result by reviewing the findings required by the Unified Development Code, including 3.4.5, as well as the conditions placed upon the zoning examiner's grant of the relief requested and the conditions including under UDC 3.4.6. The findings required for the grant of a special exception in this case includes meeting the standards expressly adopted by all codes and regulations for that type of land use, for the land use class applicable to the proposed use. This proposed use is for a electrical substation to be used as part of its transmission system in the Midtown Reliability Project. Additionally, the required findings does not adversely affect the adjacent land uses or the surrounding neighborhood, or that such adverse effects can be substantially mitigated through the use of additional conditions as provided in section 3.4.6, provides for adequate and efficient vehicular and pedestrian access and circulation vehicular parking, can be adequately and efficiently served by public facilities and services such as water, stormwater, drainage, fire, and police protection, and complies with the general plan in any applicable sub-regional area or neighborhood plans. The testimony before the zoning examiner in this case was provided in January and February of this year. That testimony was reviewed by the zoning examiner. The zoning examiner found that the appropriate finding was to grant the special exception given that the parcel under consideration was appropriately consistent with the UDC. The appellant's argument is related to the requirement or a requirement that the transmission lines connected to the substation not existing on the parcel be completely undergrounded. And the zoning examiner, in finding that the special exception was appropriate, found that that was not an appropriate condition given that the parcel itself complied with the UDC. In today's proceeding, what will occur is that the appellant will provide their presentations first, and they can reserve time for rebuttal if they wish to. The applicant will then reply and have their own presentation, again having a rebuttal if they wish to, and then we'll have the public hearing, which will last no longer than an hour.
All righty. So did you want to add anything, Madam Clerk?
I think that the city attorney covered it well, as long as there are no questions about the order of appeal and related public hearing.
All righty, so the applicant is going to present, and then the appellant, the appellant, I'm sorry, is going to present, and then we're going to have time to rebut, right? And then we're going to open up the public hearing.
Correct, Honorable Mayor. So it'll be the appellant, the applicant, and then if the appellant wishes to reserve time for a rebuttal of the applicant, they can do that.
Okay. Alrighty, so is the appellant present? Alrighty, please, I know that there's two, so if, can our first appellant come forward? According to the city clerk, your time is combined for 15 minutes, okay?
So I'm going to go, is this on? Can you hear me? Okay, so I'm going to go as fast as I can. I don't want to go so fast, but I don't have a choice. Good evening, Mayor and Council. My name is Daniel Dempsey with Underground Arizona. Like I said, I'm going to go pretty fast here. So for details, please review the written record. There's an extensive written record that you should review. We are appealing the zoning examiner's decision to approve the Vine Substation Special Exception Permit without mitigating the impact of new on-site or off-site 95-foot tall high-voltage transmission lines to adjacent property or the university area. Undergrounding new utility lines has been preferred or required by the UDC in special exceptions for decades. This boils down to two issues. One, what is required by UDC 3.4.5 to grant a special exception permit? And two, what conditions are allowed to be placed upon a special exception permit by UDC 3.4.6? UDC 3.4.5 requires that you look beyond the strict parcel boundaries in determining a project's impact. Clearly, two zoning examiners have had different takes on this issue, one an attorney and the other not an attorney. The attorney took the position that you must look beyond the parcel boundaries at transmission line impacts and denied TEP's application. The non-attorney did not and invented new TEP requested limits on his authority. It is our opinion that these limits are arbitrary and erroneous. If you are not allowed to look beyond the parcel boundaries, then you could not, for example, create requirements to mitigate the impact of new traffic from a large building by requiring new turning lanes or crosswalks or speed bumps or other traffic calming. We disagree. You absolutely have the requirement and authority to assess and mitigate the full impact of a project, and not merely what is within the parcel boundaries. Clearly, city staff and TEP, not even a year ago, agreed with us because special exception conditions on the two intersections of this very same project went well beyond the parcel boundaries to require distribution undergrounding and the removal of substations. Logically, one must consider impacts beyond parcel boundaries to create conditions mitigating those impacts. In fact, until this application, TEP has always included transmission lines as part of its substation applications. As the record shows, this is the only application where TEP went so far as to not just exclude the transmission lines, but say they could not be reviewed. At a minimum, TEP cannot be permitted to get approval by omission of material facts. That all being said, we can set aside UDC 3.4.5 requirements because even where undergrounding new electric lines not required by law, you can make following plans a condition under UDC 3.4.6. which allows you to protect the general welfare of the community. It is inescapable that if you read the University Area Plan, Plan Tucson 2025, the West University HPZ, or any other policy directives formally issued to guide City of Tucson development, that the city's goal is gradual aesthetic improvement, not decline. Encircling the University of Arizona in 95-foot tall transmission lines, 2 to 3 times taller than any existing lines in the area, is contrary to all city plans and directives. Why? Because new economic development does not occur in cities that do not care about or protect their view sheds. Developers don't want to build new high-density infill development mere feet from or looking at transmission lines. Nobody wants to live under transmission lines. Why would we put new overhead transmission lines through the densest part of the city by inventing some contrived technicality for TEP? It is not TEP's job to protect Tucson's interests. It is not the city staff's job to protect Tucson's interests. It is your job as the elected representatives of the people. In 2020, TEP, on its own accord, eliminated the Euclid route because of conflicts with adjacent land uses. Then on September 1st, 2021, when Euclid surfaced again as a route, you unanimously told TEP and city staff in a special meeting and a written directive that Euclid must be rejected and TEP needed to underground on Campbell. The facts have not substantively changed since then. In fact, we fought to keep Campbell as a route before the ACC because we expected this very situation. TEP has belligerently plowed forward, including suing the city and losing, and including having the ACC adopt a policy statement banning undergrounding and losing on appeal. To put TEP's belligerence in perspective, Central Phoenix has over 14 miles of underground transmission lines. Tempe and ASU have over 8 miles of underground transmission lines. Chandler has over 7 miles. APS has over 60 miles of underground transmission lines. TEP and Tucson have 0. Not because we can't, but because TEP doesn't want to. So it fabricates all these excuses as to why it cannot do it and tries to pit neighborhoods against each other. But TEP not wanting to do it does not make the law optional. As the record shows, cost is a non-issue. APS's costs are not substantively different than TEP's. There will be no rate increases because of undergrounding 2 miles of transmission lines. In fact, TEP has already spent more money fighting city plans and ordinances than following them would have cost. You have to disincentivize such wasteful behavior to protect ratepayers, because TEP admitted in its rate case that it earns money on delays. In closing, you have the legal power to condition the Vine substation special exception permit on TEP undergrounding its new transmission lines within the university area plan, as Section 6, Policy 6 of that plan has directed since 1989, and as Guideline A25 of Plan Tucson 2025 has directed since 2025. We believe such a decision is required by UDC 3.4.5 and precedent, but even if you disagree, you can create such a condition anyways. UDC 3.4.6 gives you broad authority to protect the city and enforce your policy directives. After all, what is the purpose of these policy directives if not this very process? TEP must not be allowed to keep treating Tucson as a second-class city. By enforcing plans now, you can sidestep a lot of other subsequent issues that will cause further delay, especially in areas with narrow rights-of-way, as TEP and the city identified over 5 years ago. Finally, if you are still undecided, I ask that you defer to the preferences you stated on the record in 2021 and defer to the preferences of Ward 6 and Ward 3. There is no good reason to break precedent to deliver damage to our community on behalf of TEP. Thank you for your time.
Thank you, Mr. Dempsey. Alrighty, we are taking time away from our second speaker, please.
Thank you. I'm John Schwartz, a member of the steering committee of the Tucson Neighborhood Undergrounding Coalition. We're comprised of 14 neighborhoods and business organizations representing between 25 to 30,000 Tucsonans. Half directly affected by the project, around half not directly affected, but deeply concerned about the adverse effects for the entire Tucson community. TEP opposes our appeal of the zoning examiner's decision to grant TEP a special exception for the Vine substation with no condition for undergrounding the transmission lines to and from it. We vehemently disagree, and apparently the Unified Development Code disagrees too. In fact, it contains a section devoted solely to requests for special exceptions, a section specifically addressing the issue of adverse effects of special exceptions, both off-site private property and on public rights of way. I'm referring to 3.4.6 of the UDC. It directly states, paraphrasing here, quote, in approving an application for a zoning exception, the zoning examiner or mayor and council may impose such reasonable and appropriate conditions and safeguards as are necessary to ensure compliance with the criteria for approval. I'm still quoting, conditions and safeguards may also be imposed to reduce or minimize any potentially injurious effects on adjacent properties, the character of the neighborhood, or the health, safety, or general welfare of the community. TEP contends that the UDC has no jurisdiction whatsoever following the ordinances and area plans or the city's special exception process for off-site properties, which what I've said clearly disputes. We also just heard from Mr. Dempsey that prior zoning examiners, such as zoning examiner Irino's ruling on the Vine substation rezoning, also oppose the reasoning of TEP and the current zoning examiner's decision about off-site effects. And Mr. Dempsey mentioned too, TEP itself agrees that the UDC does apply to it as regards setting conditions to mitigate adverse effects on off-site private property and public rights-of-way. It did so when it concurred in the city's decision last fall to construct the same project underground as at TEP's expense across the Broadway-Euclid intersection. In our written submissions to you, we have described the multitude of harmful historic, economic, safety, and aesthetic impacts of overhead transmission lines imposed on the directly affected neighborhoods and also on the community of Tucson at large. UDC 3.4.6 gives you authority to insert conditions on the Vine rezoning exception to mitigate each of these effects. The numerous harmful impacts of overheaded utilities, in fact, is precisely why the city's university area plan includes a specific provision stating that utilities be placed underground wherever possible. This 5.2 square mile area in Tucson encompasses every income and socioeconomic level of the community. It is one of the most economically diverse areas in the city. I emphasize this because some people may think that undergrounding only serves wealthy areas. One example of, in the university area, of a lower income area is Jefferson Park neighborhood, which borders on the Vine substation. It has a median household income of $42,000, well below the $57,000 median in Tucson and the metropolitan area median of about $73,000. The same would be true for Feldman neighborhood and other neighborhoods along the route. Stringing dozens of massive 100-foot industrial overhead pylons and lines looming over everything else along the route in this area does not comport with the university area plan, and so opposes this legal requirement of the UDC, meaning that under the UDC, a zoning exception cannot be granted in this case unless conditioned on undergrounding. With all this in mind, I respectfully ask you to permit the Vine substation exception only on condition that the transmission lines to and from the substation are placed underground, at least within the area bounded by the university area plan, as UDC 3.4.5 requires, as UDC 3.4.6 invites you to do, and in line with what Mayor and Council voted unanimously to do several years ago when you ruled Euclid Avenue out as a route. Thank you for your consideration. We hope that you will grant us a few minutes to respond to TEP's presentation in the same manner as you gave to TEP to respond at the last hearing on the intersections. Thank you so much.
Thank you, sir. Is the applicant present? Okay, please come forward.
Good evening, Honorable Mayor and council members. Thank you for the opportunity to speak with you this evening. For the record, my name is Stephen Eddy. I am the Director of Public Affairs for Tucson Electric Power, 88 East Broadway. We appreciate your time, your leadership, and your continued engagement on issues that are critical to Tucson's future. Tonight, I'd like to do two things. First, provide context on the Midtown Reliability Project. in the extensive public and policy process that has already occurred. And second, explain the Vine substation, its benefits, and why the zoning examiner's decision should be upheld. Throughout, I want to emphasize one central theme: collaboration. That is how these series of projects have been shaped, albeit challenging and contentious at times, but also how we continue to work with the city to ensure we are meeting the needs of our community, not just by providing an essential service to our customers, but also working with our community stakeholders. The City of Tucson and TEP have recently entered into a historic energy collaboration agreement, reflecting a shared commitment to work together in service of the community. That agreement establishes a framework for ongoing coordination focused on energy reliability, affordability, resilience, and long-term community priorities. Importantly, it recognizes that significant infrastructure investments, like the previously decided Midtown Reliability Project transmission line, require early, consistent collaboration between the city and TEP to ensure they are planned thoughtfully and serve the broader community interest. While Midtown Reliability Project and the present Vine substation predate the agreement, it reflects exactly the kind of deep coordination, engagement, and partnership that the ECA is designed to formalize and strengthen moving forward. So let me address the Midtown Reliability Project, a process that has been thoroughly decided. Mayor and Council, the project before you today did not start here. The Midtown Reliability Project has been the subject of years of public process, legal review, and collaboration. The project began in 2019 and resulted in a state approval of the transmission line route in September 2024. Trying to go to the next slide if possible.
I think you have
There
to
you go.
point behind you.
Okay, perfect. The city played a direct role throughout the siting process, not only as a stakeholder, but as an intervener in the case. Underground Arizona was also a key stakeholder and an intervener in that case. Additionally, the city has also established a policy relating to transmission lines in its jurisdiction by establishing the Gateway Corridor Special Exception process, which has already been utilized as part of this project. Through that process, Underground Arizona was an active stakeholder offering arguments largely similar to the arguments before you today. The mayor and council approved 2 crossings as overhead and required 1 crossing at Broadway and Euclid to be undergrounded, reflecting a balanced policy decision. These decisions are final and reflect a robust and transparent public process, one in which Underground Arizona, the appellant, fully participated both in the ACC line siting proceeding and in the city's Gateway Corridor Special Exception process, where undergrounding was specifically addressed and resolved. Having been a party of those proceedings, they cannot relitigate those same issues in this appeal. I think my attorney friend would call that collateral estoppel. This appeal has nothing to do with the special exception land use permit for Vine substation, but entirely on continued opposition to the transmission line, which we recognize. To that end, I want to be clear about the broader Midtown Reliability Project transmission line. This line has already received a certificate of environmental compatibility from the ACC and authorization from Mayor Council to cross the 3 gateway intersections that I referenced before. All requirements for constructing the line have been satisfied. More importantly, it delivers important system-wide benefits, including strengthening reliability and supporting growth throughout the region, including Keno Substation in Ward 5. And for that reason, TEP will move forward with the construction of the Midtown Reliability Project to deliver on those benefits. Let me address Vine Substation and the benefits and community values it brings. The Vine substation is fundamentally about one thing: ensuring reliable, resilient electric service for Midtown Tucson, both today and for decades to come. By connecting into the Midtown Reliability Project, the Vine substation allows the Midtown area to fully realize the benefits of a modern, more reliable, and resilient electric grid. It supports key community assets, including the University of Arizona, Banner UMC, and the surrounding neighborhoods, and importantly, it helps serve the core of the city's community corridors areas, particularly in Ward 6, where Tucson is prioritizing infill development, housing, and walkability and transit-oriented growth. We can see this throughout the Midtown area and around the U of A, including at the corner of Campbell and Speedway, a stone's throw from Vine Substation. And importantly, this project is not just about adding infrastructure, it's about modernizing it. It enables the retirement of aging substations, reduces overhead infrastructure, and significantly expands underground distribution, resulting in long-term benefits for the community. Midtown is currently served by infrastructure built generations ago, at a time when energy use looked much different. Today, swamp coolers are replaced by ACs. Homes now have battery storage systems and solar panels. EVs are proliferating throughout Midtown, and more connected devices rely on reliable energy. These changes, combined with an aging 46 kV infrastructure nearing capacity, require system upgrades. And in fact, Vine Substation will enable further proliferation of those technologies, like solar, like storage, like EVs, and resiliency within our community. So let's talk about strengthening reliability in Midtown. The Vine Substation enables a modern, redundant system that prevents outages, provides multiple delivery paths of energy, supports critical institutions like the U of A and UMC, and meets current and future energy demand. It's also a system upgrade that reduces infrastructure over time. I reference collaboration as part of the Midtown Reliability Project. It's also about compromise. As a result of the extensive public process for that project, there are specific conditions in the CEC that address undergrounding and reduction of overhead infrastructure. 100% of the distribution lines along the project route, as noted in this map here, will be placed underground. That is approximately 6.3 miles of distribution lines and over 20 miles of that low-hanging cable that we all see. Approximately 19 miles of overhead infrastructure will be removed, which includes the 46 kV system that this 138 system will replace. It results in long-term reduction in above-ground infrastructure and improved neighborhood conditions. While this is many years ahead, the Vine Substation will also allow the retirement of up to 8 substations, again, as identified in this map, throughout Midtown, which creates an opportunity for infill development, including affordable housing, and strengthens collaboration between TEP and the city for those efforts. Let me talk about site selection. This site was selected after evaluating 15 different locations. It meets key critical criteria, including proximity to demand, compatibility with surrounding uses, and adjacency to existing utility infrastructure. It happens to also be located adjacent to an existing substation, the exact use that we want to replace it with around the bounds of this parcel. Let me talk about compatibility with residential areas. The project has been carefully designed to be compatible with its surroundings, incorporating architectural treatments, landscaping, public art, along with a 20-foot buffer along Vine Avenue. This was considered in the design review board, as well as specific conditions placed by the zoning examiner to ensure that there is compatibility with the adjacent uses. Additionally, TEP operates multiple substations near residential areas throughout its service territory. These facilities operate safely and reliably. The Vine substation ensures Midtown Tucson will have a modern, reliable energy system that supports future growth and community needs. So in closing, I want to recognize the process that has brought us here. TEP appreciates the zoning examiner's careful and thorough evaluation of the Vine substation special exception land use permit and the deliberative process that led to the February 17th decision. His findings are clear. I encourage you to read through them. I don't have time to address his findings entirely, but it is clear. It is subject to the parcel. The permit is subject to the parcel that we are considering for the Vine substation. That decision reflects a clear understanding of the scope and purpose of the project, the applicable provisions of the UDC, and the distinct legal proceedings that have already resolved the siting and construction of the associated transmission facilities. We also want to acknowledge staff for their thoughtful and comprehensive review of this application. Staff's recommendation for approval, together with the conditions ultimately imposed by the zoning examiner, demonstrate a balanced and thorough consideration of land use standards, neighborhood context, and community concerns. Importantly, the appeal before you does not identify any deficiencies with the Vine substation's compliance with the UDC or the special exception findings. Instead, it raises issues about the transmission line that are outside the scope of the zoning review, beyond the zoning examiner's authority, and are not appropriate given the prior proceedings. This has been a long journey, and we appreciate the steps that we have gotten to where we are today. It has not been easy. We understand the concerns, but we feel we have gotten to the right place, the right site, and this is the right use for this site. We appreciate your consideration, and we respectfully request that you deny the appeal and uphold the zoning examiner's approval. Thank you.
Thank you. I have been informed by the clerk that the time remaining, the applicant and the appellant have time for rebuttal. Both landed at 1 minute, 30 seconds for rebuttal. So I'm going to invite the appellant, I'm sorry, I keep confusing this. Appellant for a 1 minute, 30-second rebuttal.
I have some procedural questions first. So in August, when we had an appeal, the public spoke first, because they might address some of the things that we would address, and then we could rebut after the public speaks. And then TEP also had another 15 minutes after it spoke. It spoke for 30 minutes in the August appeal. So I just want to make sure that we're having some consistent treatment here.
Alrighty, Mr. Attorney?
If I may, Honorable Mayor, the mayor and council may proceed with the public hearing first and then ask questions of or reserve the 1 minute and 30 left for the applicant and the appellant in your discretion.
So we do have the possibility of opening the public hearing and then having some additional time for rebuttal. Okay, so what we're going to do, let's see, is open up the public hearing. So this public hearing is scheduled to last for no more than an hour. Speakers are limited to 5-minute presentations. We don't have many speakers. We have 3 cards for the public hearing. So when I call your name, please come forward and make your presentation.
I apologize, Honorable Mayor.
Yeah.
It occurred to me that neither of the party discussed what the actual special exception request was. So I thought it might be helpful before we get to the public hearing to describe what that was for the mayor and council. The actual application requested from TAP requested a relief from 20-foot setbacks from the north, south, and east sections of the property, as well as an increase from the 10-foot wall allowed to 13.5 feet. That was just the requested relief from TEP, which the zoning examiner granted.
Okay. So we can start the public hearing? Okay. So we're starting the public hearing. Please come forward when I call your name, make your presentation, state your name, whether or not you live in the city of Tucson, whom you are representing, and whether or not you are a paid speaker. The first person that I have is Rosemary, I think, Bolza?
Yes, I'm Rosemary Bolza. My last name is spelled B as in Bravo, O-L-Z as in Zebra A. I live at 1432 East Leicester Street. I am not a paid speaker. I live within 1 block of the substation. And I have a safety concern because Banner, the hospital is right there. And it's the only Trauma 1 center in southern Arizona. And helicopters come from all over. They're not all familiar with the hospital or the landing pad. And I see them flying in, and sometimes circling. And the last thing we need is poles with these high voltage transmission lines. The helicopter pilots are bringing seriously injured people, and they are having to navigate by line of sight, and we do not need any other hazards for them to navigate. Also, the university has a gas-powered electric generating plant that's as close to the hospital as you are to the door outside. And this, to me, is a real hazard without the poles and these high-powered lines. But this adds another layer of hazard. If a helicopter crashes into the gas-powered electric generating plant, it would disable Banner, and we have nowhere to take those patients. And I had some pictures that I wasn't allowed to put on the screen. But I would ask you to think hard about this. And if I would really want people to come and actually walk through this and see it, because life is precious and we have to look for the safest way to build our infrastructure. And having the high voltage lines above ground, they are more vulnerable to vandalism, to drones, to all of this technology now that people can use to cause harm. And so I ask that you require, if you approve the substation, that you require that to be undergrounded in this very important place for the entire community. Thank you.
Thank you, Ms. Bolsa. Our next speaker is Randy Hutchinson, maybe? Randy?
Hotchkiss, I think you left.
I think it's Hodgkins. I can't read the writing, so I'm so sorry. Randy? Okay. And our next speaker is Betsy Larson.
Hello, my name is Betsy Larson. I'm president of the West University neighborhood, which includes Main Gate Square. For the last 7 years, it's a long time, TEP has done a great job of pitting neighborhoods and causes against one another. So I'd like to address the wards not directly impacted by this specific exemption tonight. How can tonight's decision help your wards? Why should you care and hold TEP accountable for the infrastructure they build? Precedent. Tonight will help lay the legal pathway for all neighborhoods. No home or school in any ward should live under high-power transmission lines. If we are successful, then we are going to look towards the future. How can we replicate undergrounding and responsible TEP infrastructure for your wards? Neighborhood plans, creating more zoning overlays, and strengthening existing laws are some of these ways. These are grassroots tools that we can expand and strengthen upon. All of us volunteers here tonight are fighting to make the roadmap for you, for your neighborhoods, and for your community spaces. TEP has fought a ridiculous amount of time for a mere 2 miles of undergrounding. Why? For a $1 billion international corporation, this project is a mere drop in their vast bucket of wealth. So what's the real reason? They're afraid of our community waking up to the possibilities ahead. They're afraid of new expectations and accountability. So again, why does this matter to your ward? Infill. There's a reason Phoenix, Tempe, and other dense cities require miles of transmission line undergrounding. Infill and density are not compatible with high-powered transmission lines at obnoxiously large poles in tight right-of-ways. West University is actively experiencing rapid increases of density and infill. We intimately understand the challenges of accommodating new infill and infrastructure failures. Adding 100-foot high-power lines into the mix is counterproductive and dangerous. So I ask you tonight, reverse and modify TEP's Vine special exemption. Underground the lines according to multiple zoning overlays and general plan. Help us empower all neighborhoods. Give them the precedent and the tools that they need to fight corporate greed. Thank you very much for hearing us tonight.
Is there anyone else wishing to be heard on this public hearing?
Yes, my apologies. I thought we only had 30 minutes. I didn't know it was open to the public.
It is a public hearing, and you do have the right to,
I'm sorry, was this gentleman first?
no, you can go ahead.
So I'll give you my card later. My name is Kathy McLaughlin. I live at 2739 East Carthay Circle. I have been part of this fight for nearly 7 years. And the disingenuousness of Mr. Eddy just makes me furious. TEP has done nothing but put barrier after barrier after barrier after excuse throughout this whole process. I am an architect and a planner. I care about what Tucson looks like. I've been on the Billboard Review Committee since 1985. And what used to be about 930 billboards in this city has been reduced to less than 270. But what has happened is TEP has taken over the uglification of our streets. If it's okay with you, what they've done on Grant Road and on Broadway and at almost every intersection that there is, then vote in their favor. But if you don't like what this is looking like, give them what they want, but make them put it underground. We don't have any fight about needing up-to-date technology. We do have a fight with putting it on 100-foot poles straight down the heart of our city through historic and dense neighborhoods. Please consider the aesthetics of this city. That's what made Tucson on the map to begin with, tourism. Tourists are going to go elsewhere. These poles are just going to take over in terms of what you see. You're going to miss the mountains. You're already missing them along Grant. So I would encourage you to please give TEP what they want, but make them put it underground, because you have the right to do that. I would also like to point out that I was in a meeting in October of 2019 held at Pima College where Mr. Ed Beck, who I think preceded Mr. Eddy, told the group a lot of lies. And when I pointed out to him that I thought Keno and Campbell were a scenic route and I didn't think his poles were going to be allowed to go up there, he dismissed me. He said I was wrong. And then John Schwartz found the ordinance. You have every right as our mayor and council, as our leaders, to require them to underground their utility on our property, City of Tucson property. You have every right to require that, and I'm asking you that you do. Thank you.
Thank you, Ms. McLaughlin. Mr. Salvatierra.
My name is Jonathan Salvatierra. I'm not a retained speaker. I'm a native Tucsonan. And I've gone over a number of video journalism and social issues with the Tucson area, and how the council and the Board of Supervisors have dealt with our immediate interests, our safety, our health, the quality of our neighborhoods. And it seems like there's some mistake, like the provider is going to do everything in their possible effort to appease the public. And that's so far from the truth. When you negotiate with them with their non-disclosure agreements, and everything is already in line within the executive sessions that you take, there is nothing but a rubber stamp that precedes it. And it's the tail wagging the dog again. And I don't know if you want to act like you're just representing stakeholders, or whether you really feel any intrinsic desire to represent the public. That is the question here now. I see every time there's a pole above ground, if any tornadic event affects it, we pay Tucson Electric 12% over the cost of replacing and repairing that pole. So why are we doing all these stupid redundant things? Why are we allowing TEP Fortis as a foreign proxy to dictate everything that goes on in this city, the 47 years of 47 kV that have been underrated and abused, the situation that we enjoy? It's implausible that anything that comes up from TEP is going to benefit the public. Their interest is totally separate and given their stakeholders' interests. So why would I say this? I've done this for over 2 years now. I came to this council 2 years and better in October of 24. And it's just like we repeat the same things, and this council hears, but they don't listen. So what's up with that? Do you care about us? Is this really an issue? Or is it just another rubber stamp because TEP has given their consent and control in their non-disclosure agreements, and all their contracts are already laid in place, And all you have to do is be nice and comfortable and just act like, oh, we're just following our direction within the limited scope of our authority. No, no, this is not right. And I'm saying this because it's really frustrating and aggravating to see the people that I love and appreciate sitting at this board that have so much more to offer their constituency. 138 kV. Gee, isn't that the same kV that Sarita is going to be requesting and supporting for Copper World? Is this a backup system? Why aren't we doing something that plans a future master plan for everything that goes on electrically and through the utilities? The Commonwealth Utility Cooperative that includes Arizona for the transmission, the counties and the cities that create their own bond issues to support the takeover of TEP. There's no more having the tail wag the dog. Why are we doing this over and over again? It doesn't benefit us. We're not independent. We're interdependent on TEP's little token gifts. Oh, here's $2 million. Oh, take it and use it. You know, we just, out of our largesse, you know, we're going to help you. This is
Thank you, Mr. Salvatierra.
abysmal.
Thank you,
And I
Mr.
appreciate your
Salvatierra.
time. Thank you for listening.
Anyone else wishing to be heard on this item? Okay. If not, may I have a motion to close the public hearing, please?
So moved.
Second.
There's a motion to close the public hearing and a second. Any further discussion on closing the public hearing? Seeing or hearing none. All those in favor of closing the public hearing?
Aye.
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 Any against? Public hearing is closed. Alrighty, we do have an hour, a minute and 30 seconds to rebut. So I believe the applicant can do it first.
Okay, so just, there's a lot of things that Mr. Eddy said that were incorrect. It's too much for me to address, but it's addressed in our writings. First of all, replacing 30-foot poles with 90-foot poles is not an improvement by any reasonable definition. And TEP has no control over the joint use attachers. So when TEP takes down a distribution pole, you still have the cable and the fiber and all those guys. They don't have to underground. It's up to them. So there's no improvement to its undergrounding some distribution lines. And he seemed to imply that the ACC controls how something is constructed. That's not how it works. The ACC controls routes. How something is constructed is up to you guys, and it's up to our plans, and our plans have been very specific for a long time. It's, you know, whether or not you agree with it, whether it's required, you absolutely should be enforcing the spirit of those plans.
Alrighty, is the applicant wishing, still,
Yeah.
Mr. Schwartz.
I just want to say that Mr. Eddy talked about a balanced decision with the intersections because one of the three of them were done underground. We're asking, in essence, for a balanced decision on the undergrounding. The route is 7 to 8 miles long. We're asking that approximately 2 miles be placed underground in conformance with the Unified Development Code. And finally, virtually everything that Mr. Eddy said, praising the project, is diversionary in the sense that it will also be achieved if the transmission line is underground as we believe it should be. Thank you.
Thank you, Mr. Schwartz. Is the applicant wanting to rebut?
Honorable Mayor, council members, I think the closing statement that I provided earlier makes it very clear in terms of where we are at in this process and the authority granted by the zoning examiner with respect to this special exception land use permit for the substation. The transmission line, obviously, we've heard, has been contentious. It has been settled. That route has been decided. Mayor and council weighed in on the underground crossings that have been considered. And today, we are considering the Vine substation. I will, though, take one moment to address one of the concerns around UMC. And I will state that they have been an active stakeholder in this process. In fact, they should have submitted a letter of support as part of this hearing, and we have ensured that their safety has been applied to the siting of this substation. But even previously, as part of the line siting decision, their concerns were addressed as part of that decision. So, thank you, and obviously, if we get to any questions, happy to address those. Thank you.
Alrighty. Does council have any questions for the appellant or the applicant or other persons who may have relevant information in order to establish the reasons for affirming, reversing, or modifying the zoning examiner's decision? And this is for
This
council.
is the time of discussion.
This is for council, yes. Yes, for questions for the appellant, applicant, or other persons that might have relevant information in order to establish the reasons for affirming, reserving, reversing, or modifying the zoning examiner's decision.
Does that include questions for staff?
Yes.
I'm going to defer to 6, 5, and 3 first.
Alrighty. I guess if there's no questions, I think this is the time and place for you all to have your questions. This includes for the applicant, the appellant, the city attorney, the city manager. I guess my question would be, can we ask questions to the zoning examiner?
If the zoning examiner is present, yes.
Yes.
He is here.
So we can ask questions to the zoning examiner as well. So, Vice Mayor?
All right, thank you, Mayor. I have a couple of questions. And I'm not sure if these will all be to the city attorney or to other staff, so I'm just ask them. First, if the mayor and council were to uphold the appeal and require undergrounding, what is the strongest legal basis for doing so, and what litigation risk would the city face?
Honorable Mayor, Vice Mayor, the strongest legal argument for granting the
requiring
appeal?
the undergrounding for,
I think it's hard for me to speak for the appellant, but I think the appellant would say that the strongest legal argument would be to uphold or to apply the university area plan in UDC 3.4.5. The litigation risk, there's a couple, and I'll go through them just so that's clear. One is that we would be exceeding the authority granted under UDC 3.4.6. In that can happen in two ways. Under the code itself, I think there would be no surprise that TAP would likely want to litigate that authority under 3.4.6 and whether or not it was appropriately applied in this case, given the request from the applicant, or the request from the applicant was to get relief from a 20-foot setback and to get relief from to an increased wall height. Those two requests, if granted with the condition, would lead to a relatively expensive construction project for them, where we grant those sorts of that kind of relief all the time without requiring anything offsite or anything like that. The other issue related to is the basis for the basis for that grant of the those conditions. The basis, in this case, the strongest legal argument I just described, would also be treating the university area plan and other area plans like it as regulation versus policy documents. That's an argument that we've already, the city has in prior litigation won against, because we argued, and Arizona state law sort of is on our side with that, is that while there are policy documents and they're appropriate to consider in things like rezonings and things like that, they're not the same as actual legislative action like the UDC, which the UDC is a regulation that can be applied and can be applied with specificity. If we were to go into court and then reverse that argument, I think the court would look unkindly on that. Additionally, the other concern that the condition would raise is that the third issue would be that while the condition may be appropriate or may not, the condition doesn't include how to pay for it. There's two ways that it could be paid for. One is either through ratepayers, if TEP wishes to, put that into the rate base, or they could invoke the franchise, which, even though it expired in April of this year, it's still under its own terms. It's still in effect and for 1 year from that April date. The concern would be that they could invoke Section 21 of that franchise, which would then require us, the city, to pay for that undergrounding, not the ratepayers, but the city. And then finally, the other concern would be that it could be seen by the court as an illegal exaction under ARS 9.500-12. The concern there would be it's similar to a taking, which we're all familiar with, a regulatory taking, which basically says that we are taking property from a property owner or diminishing its value. And if the court finds that that is true, we could be required to pay for that, the city.
Okay, I appreciate you bringing up the interpretation of neighborhood and area plans, because that is something that concerns me. So are you saying that that would establish a precedent that treats those plans as regulatory documents rather than guiding policy documents?
That could be the interpretation by the court and could create its own precedent in that way, which would also require in other cases where we use rezonings or special exceptions, the concern could be that we would not be able to do the kinds of things that I think have been discussed in the proceeding today, like urban infill, where we use the flexible lot development, for example, to give relief for zoning regulations or things like that in order to create more affordable housing, more urban infill, those kinds of things.
Okay. So I heard from a lot of the speakers today, and so I want to better understand why we see more substantial undergrounding of utility infrastructure in the Phoenix metropolitan area than we do in Tucson. Is that driven by different development patterns, different utility requirements, different regulatory structures, any combination of those factors, and what lessons, if anything, should Tucson be learning from those communities?
I'll answer for the legal/experiential to the extent I know. I lived in Phoenix for about 10 years, and Phoenix infrastructure is much newer. A lot of the houses built there and the structures that were built there were built in the 90s, as opposed to here in Tucson, where we go back to the 50s and 60s, especially in the downtown area. In addition, in terms of the legal structures, I think there are different codes, different applications of those codes. We have a gateway corridor. They don't necessarily have one that's similar like that. So it's just a sort of community preference as far as I understand.
Okay. And then my final question is, like, we hear this debate, since the time I've been on council, that we've been talking about undergrounding. Could mayor and council consider a potential policy for a citywide undergrounding framework? I'd be interested in understanding if if there's such a policy or regulatory infrastructure that we could implement here in the city so that we have more of a consistent standard rather than addressing these on project by project basis.
I think that's absolutely within the mayor and council's purview. Obviously, the mayor and council has already taken the steps to designate the gateway corridors and the scenic corridors within the city as requiring underground, and we've been successful in holding TEP to those requirements, even though, even through litigation if we need to. If the mayor and council, and again, this goes to the difference between the policies and the regulation, if the mayor and council really want to do that, they can pass through the planning commission and the adoption process of new codes or land use codes that would accomplish that result.
That's all, Mayor. Thank you.
Councilman Lee?
Thank you, Mayor. I have a question for the city attorney. And city attorney, you mentioned this 2 separate times, but I just want to clarify because there's been a lot of components in the conversation tonight. For the special exception, am I understanding correctly that it's really 2 components? TEP is asking to be able to go to 13.5 feet for a block wall. That's one component versus 10 feet. And have an exception from 20-foot setbacks, so they can have shorter setbacks. In English, is that the 2 components of what they're asking for relief for?
Honorable Mayor, Councilmember Lee, that is correct. That is the request that TEP was making in its application for a special exception.
Okay, I just wanted to kind of recenter myself to make sure I was understanding the scope of what we're considering tonight, what's in scope and what's out of scope. So I just wanted to make sure I was understanding that correctly. That's my only question, Mayor.
Thank you, Councilwoman. Any others? Councilmember Dahl.
Follow-up question to that. There was an earlier attempt to get a special exception for this substation, and the ruling was that undergrounding of the lines would have to occur. Is that correct? And if that's correct, what was the special exception being applied for then? Was it the same thing?
Honorable Mayor, Councilmember Dahl, I don't believe, and I correct me if I'm speaking about this the wrong special exception. There's been 2 special exceptions processes related to this line. The first was the original Vine special exception request, which was denied because the line hadn't been determined at that point. And then there's also a second special exception process, which actually involved 3 separate special exceptions. Those 3 special exceptions were for the intersections crossing gateway corridors.
I'm asking about something else.
Sure.
And I think the applicant was the one who talked about and maybe they can answer the question. Appellant.
Now you're doing
Mayor has
what I was
affected me.
doing. Okay.
Daniel, can you answer that question?
Appellant.
And then maybe Steve, you can see if he got it right.
So ask the question again, I'm sorry.
There was a previous special exemption effort at the Vine substation. What were they asking for, and did that, you said that it was denied?
Right, so my understanding is they were asking for the same thing. And what Roy leaves out is that he denied it because we didn't have a route determined, but the reason why he denied it was because the route wasn't determined because he couldn't determine where the transmission lines would be, right? There's no reason to deny it if you're not tying it to the transmission lines because the ACC only has jurisdiction over the routing of transmission lines. That's what doesn't make sense about what Roy just said. And then something else that he spoke on our behalf. So a special exception, you don't have to grant a special exception, right? A special exception is for to be allowed to build something you are not otherwise allowed to build. So whether it's a big thing or a little thing, you're not allowed to build it. And when you ask for it, you can create conditions. And we think, we also disagree, so you can create a condition that you underground the transmission lines, right? The other thing is that he mentioned the requirements. So again, this is really confusing because the UDC 3.4.5 requires that you comply with the area plans. It's not a suggestion, it's a requirement. So the idea that and Roy has told me this before in the past, so if it's a special exception, they're required. If it's not a special exception, yeah, they're just suggestions, but this is a special exception, so they're required. So again, there's a couple things there that didn't make any sense to me. And I'm happy to answer any other questions, thanks.
I'd just like to add one thing. Because the route wasn't decided, the examiner didn't know whether whether in the end it would comply with the UDC, with the university area plan. And so he was really saying it had to comply with the university area plan before it could be approved. Thank you.
Can I do a follow-up question to the current special examiner?
Sure.
Yes.
And kind of following up that, why did you do something different than was done before? Or do you disagree with that analysis? And hi, by the way. Yeah.
Good evening. I'm Jim Mazzacco, and I'm the current zoning examiner. So in this particular case, it had to do with a substation, and the line had been established. And there was a lot of the testimony. I heard at least 6 hours of testimony, and a lot of that testimony had to do with the laying of the transmission line underground or above ground. What I had to focus in on was this single property at Vine Avenue. Did it comply? And I looked at it, and I listened to the testimony, I looked at all the materials, and I made my decision on that. I could not make a decision on whether the transmission line should go above ground or below ground because they're in the right-of-way. There's a part of the zoning code, section 1.4.2G, says zoning applies to private properties except right-of-ways. So I applied to the property. I couldn't jump into the right-of-ways and start regulating those. You have a document that regulates the right-of-ways. That's the franchise agreement. Franchise agreement handles right-of-ways, zoning code handles substations. That's just how it's written. So I handled the substation as a single property, and I applied the university plan and the general plan to make it fit into that situation. Because a substation is only permitted in industrial zones. It's a special exception in commercial zones and residential zones. So you have to have special conditions to make it fit. So we looked at noise, we looked at light, we looked at the gases they use, we looked at the size of the wall was an industrial wall. That's what it's going to be, 13.5 feet, because that would mitigate some of the federal concerns of the property. But we said, okay, if you have a 13.5-foot wall, it can't look like an industrial wall when it's in a neighborhood. You have to put public art on the wall. So that's how we fit it together. And that's why ours is different, because in the one case with the gateway, that does apply to right-of-ways, but it has a specific part of the zoning code that talks about transmission lines. It's called A13, that part of the use-specific standards. A13 isn't in the use-specific standards for substations. So we couldn't use that as a criteria to evaluate this property. So that's the reason. And as far as Mr. Iorino's, he basically said, there's no line, so I'm not going to approve the substation. Well, in my case, there was a line that was approved. So I couldn't use that argument. I just looked at the substation, and I made my decision from the zoning code and the use-specific standards, and looking at the general plan and the university area plan, which policies fit to make this substation fit into this particular situation. And that's how I made my decision.
Any other questions? Any questions? Councilmember Cunningham.
So I'm just trying to figure out, when you made that decision on the zoning code, were we granting we granted a special exception when we allowed the substation to go by the hospital? Because I don't remember that being a special exception.
That's what this is all about, because That property is in the R2 zone. It can only be allowed as a substation, as a special exception. So what you're voting on is appealing my decision, where I'm saying a special
I get all that.
substation could be
I understand all
allowed.
that. I was thinking that when I'm going back to when we didn't have a line established. So that was when the special exception got denied.
Correct.
In the first place, was because the line wasn't established. And when we had the vote on the new special exception, was there consensus on where the line was going at that point?
Well, this
Or
is
marginal
that
consensus?
No, what you're talking about, this current case, correct?
Yes.
So there's two special exceptions. There was the previous one and this one. That's the only ones. So the one in front of you now, there is a line that's been approved.
Okay.
Okay?
That helps.
Okay.
For me, my question might be legal or zoning examiner. Would we, even if we were to approve the appeal, would we as a mayor and council be able to request in this particular case the undergrounding of the lines moving into the substation?
So, Madam Mayor, members of council, I think what you're asking is that if you were to affirm the zoning examiner's decision, but add conditions to that decision, is that what you're asking?
Yes.
Whether you can do that or not, I've explained. I think I can't say you can't do that. What I would say is that those significant litigation risks that I just described would be the concern that I would have in doing that.
So on the litigation risks that you have, you've said that you are concerned about the city of Tucson getting into a position that we would support but have argued against.
Correct. So the concern first is that precedent where we start to use policy documents, the area plans as regulations that aren't adopted through the normal UDC process as regulation, would then create a precedent where we would be limited in applying things like the flexible lot development or other tools that we use to create infill development. That would be one of the concerns. In addition, the other concern is who would pay for that undergrounding, because I think there's a real risk that we would be required to do that under our current franchise agreement.
Is there a possibility, and I think the vice mayor asked this as well, is there any other way of, as a mayor and council, creating land use codes that would require undergrounding throughout the city of Tucson?
Absolutely. The mayor and council have the ability to legislate, as they always have, in terms of creating additional codes or expanding the use of the major streets and routes plan, which creates the gateway corridor and the scenic corridor, and they could do that in many ways.
Would going into a lawsuit, if we were to, we're assuming, right, if we were to deny the exception, would it tie our hands as mayor and council to go against any particular pieces of neighborhood plans or area plans?
It could, based on that precedent I just described earlier, yes. Mm-hmm.
So I'm just thinking about the time here that I've been on the council, and I think we've done a few things. And one of the instances is the Mountain Enclave example that mayor and council voted against a particular piece of a neighborhood plans, and that action was consistent with the general plan and resulted in a significant increase of density in a particular area. So we went against the neighborhood plan, a piece of it, but it was consistent with the general plan approved by voters. And it created lots of density. The other piece I'm thinking about is that mayor and council took a position against, I'm sorry, West University, but we took a position against West University to create the density around just outside the university, the main gate, because the neighborhood plan had just a 3-floor,
High requirement, correct?
density restriction. And so the mayor and council voted against that particular piece of the neighborhood plan, and we were able to create transit-oriented development in that piece and that piece alone. Would it limit something like that?
It could, Your Honor, just because that precedent, especially if we were in litigation, obviously the mayor and council can do things differently in different proposals, but once we get the courts involved, they create precedent. So if that litigation were to say that, the area plans have the weight of planning code in the same way that the UDC does, that could limit what we could and could not do, especially in those projects you described, which create those infill sort of developments that you're talking about.
Any other questions? Councilmember Dahl and then Councilmember Barajas.
So Roy, my understanding of area plans was that they were to make recommendations for actions that are done by the Planning Commission and by mayor and council. So I'm not sure, they're recommending to us, and it was done a long time ago, that we don't have big overhead lines. In fact, all utilities should be undergrounded. That was the wish for the whole university area. So I don't see how that's a precedent saying that we're using that to regulate. I think we're taking advice from this plan, and we have our own, we make our own actions, we make our own decisions on this. So that would be my non-lawyer pretending to be Perry Mason review of the situation. Now it occurs to me that if we want TEP to underground, and I do want you to underground this, it's going to look nicer. Tucson will benefit. It's not tremendously expensive in the scheme of things, and I think it would be a great thing for TEP to do. But we have if we don't want the overhead lines, and there's a lot of people who live in Ward 3 and Ward 6 who don't want them, we have two choices tonight, and tell me if I'm wrong. One is we just deny this special exemption. Now, what's the legal risk if we just deny it? Because we don't want a 3.5-foot wall, or for whatever reason. We don't even have to express a reason. It's a special exemption. They're asking for something special. We can deny it, correct? But is there potential litigation from that?
There's potential litigation from that. It's a little bit different in terms of what the outcome might be, but I think it's still, the risk of litigation is similar. And I think in that litigation, there's still the opportunity for either side to argue that the reason why, because of the discussion here at Mayor and Council and with the public hearing, that the reason why you did decline to affirm that special exception was because of the area plans, and that litigation could lead to a similar result, not exactly the same, but it's possible.
And in that court, I would argue, what's the use of area plans if you can never use their recommendations? I mean, that doesn't make any sense going through that process. So, but thanks for the answers. This is an incredibly complicated thing, isn't it?
Councilmember Barajas.
Thank you, Mayor. Well, I guess need a little bit more clarity in terms of the right-of-way and infrastructure impacts. How would this affect our existing road improvements? And we still don't have clarity, right, of who will cover that cost?
Honorable Mayor, Councilmember Barajas, that's correct. So to your first question, the impacts are pretty significant. If you're undergrounding a transmission line, that takes quite a bit, and I don't want to take away from TEP, so hopefully they'll correct me if I'm wrong, and I encourage you to ask them about this. But my recollection from our ACC power line siting committee hearing, they presented testimony and evidence that the way you have to underground a transmission line includes sort of tearing up basically a lane at a time. And so however long that transmission line is, you basically are taking out an entire lane of traffic. For however long it takes to do that, that can be, a significant undertaking. So, you're talking about taking out a lane of traffic for, I don't know, a couple months. But again, I'm not the expert. That'd be more TEP. And then, I'm sorry, the other question was how we pay for it. Again, the concern is that that TEP could invoke that Section 21 of the franchise, which would require us to pay for it, and/or it would be paid through rates.
Any other questions? Councilmember Cunningham.
I've got some things I just want to clarify, and forgive me, it's been a minute. I'm trying to figure this out. I remember that part of this includes some distribution lines being undergrounded. Is that correct? So there's undergrounding of distribution lines only on the route. And then the transmission lines that don't currently exist go where the distribution lines would be. Am I essentially saying that correctly? Then we had some exemptions that we voted for, or I voted against actually, about 4 months ago with the 3 intersection thing. So my hang up on this whole process back then was that, all right, transmission lines, if we don't underground them, we risk the ratepayers, we risk prices going up, we risk litigation, all that rigmarole. And that may be true, maybe not true, whatever. But if we're gonna approve the exemption, then why don't we get something else? Because I still have that same thing in my mind about Oro Valley and Scottsdale and Paradise Valley and Chandler and Gilbert and, the 18 other jurisdictions that have underground distribution, and we can't get a little extra underground distribution in other areas or in neighborhoods nearby or a couple extra easements, at least we get something extra. I mean, if we've got to build, if the transmission lines are really expensive and undergrounding transmission lines are really expensive, can we get something extra to underground? So that was kind of my thought process back then. So it's really an interesting situation we have here, that we have a 3.5 foot variance on a wall and the setbacks where the poles already exist. But I don't know if that's what we're talking about. What I think we're talking about is whether or not the rules applied, that there was an expectation for undergrounding prior to this application. So did we have a requirement for them to underground transmission lines when they submitted this?
Are you talking about in this area? I'm sorry, Councilmember.
I'm talking about in general.
Yes.
We already adopted our transmission line undergrounding requirement when this application was set forth.
Correct. So if I understand your question correctly, Councilmember Cunningham, the requirement that we have in the city of Tucson is to require that all overhead lines be undergrounded in the areas of the Gateway Corridor and the Scenic Corridor. In this area, that is not a requirement under the UDC.
Any other questions? What is the council's pleasure? Councilmember Schubert.
Thank you, Madam Mayor, members of the council, and everybody who's here tonight spending the time on this issue, and for everybody who's been spending time on this issue for the past 7 years. I've been following this issue since well before I was elected as a candidate for the seat, which isn't too hard since I've only been in for 6 months. I'll be honest, I did not really take this issue very seriously at first. I thought that this was about privileged homeowners wanting undergrounding in their neighborhoods. And I didn't understand because I grew up in Las Vegas where they gave up on stuff like that a long time ago. Neighbors don't organize for things like that because they know they're not going to be listened to. I thought it was a specific niche of people, a very specific issue that didn't affect everybody in the city. But I took the time to meet with the organizers and with the neighbors who wanted to tell me about this topic. And in the bigger picture, what ended up selling me was the precedent that is set by this case. I have been told by members of the Underground Coalition that they do not see this as an issue that affects only them. And you heard from John that the split of people who are directly affected by this and the split of people who are not is pretty even. The sense that I was given that really sold me was when I was told if this particular discussion over the Vine substation does not go in the direction of the neighbors, then the neighbors feel that that's it. That's probably the precedent, and there's no need to argue anymore about undergrounding. I feel optimistic about what I've heard here at the dais tonight. I do think that this is a yes-and situation where we need to look at a broad citywide policy around undergrounding so that we don't have to keep doing this. It's well past my bedtime. And the neighbors are really unified about this. I was elected to represent and to serve the community. Like Councilmember Dahl, I also am not a lawyer. I don't even pretend to be one. I feel it is my duty to use the discretion that has been granted to me as an elected official and to use my authority. I understand that neighborhood plans and area plans are not regulatory and that the Unified Development Code, the UDC, is regulatory. I understand the legal risks, but from where I'm sitting thinking about 7 years of organizing, I think that we're gonna face litigation whether we uphold the zoning examiner's decision or not. So the legal risk is there on both sides. I'm not a lawyer, so I'm scared when I hear about all the risks. But I heard a lot of coulds. I didn't hear anything that was 100% definitely we have no shot. And to me, that means we still have a chance. At the end of the day, I was elected to represent people and not just when it's not risky. So I moved to modify the zoning examiner's decision by approving the special exception land use permit subject to the zoning examiner's conditions and adding the following condition, requiring any currently planned or future connecting transmission lines in the university area plan and in any residential neighborhoods to be placed underground in accordance with the duly adopted directives of the university area plan and in accordance with our own voter co-created and adopted general plan, Plan Tucson. Thank you. That's my motion.
Second.
There is a motion and a second. Any further discussion on the motion?
Can I just add one more thing? There's another point I forgot to make.
Yes,
and
yes,
it was about the neighborhood plans and the precedent, because a lot of the stuff that the city of Tucson has done to encourage density, flexible lot development, all that is awesome. I think it's really great. Neighborhood plans, I think that we should have the purview to pick and choose the things that we want to enforce. Because we've done it in the past, we have used pieces of the neighborhood plan to make our arguments. I don't think it's an all or nothing. And I also think we need to look at neighborhood plans if they're that counter to what the city's goals are. But in this case, I would like to pick apart the plan and say, I want to use the part that tells us that we need to underground. And that's my motion. Thank you.
Any other questions by the council colleagues? Councilmember Cunningham.
I just need clarification. Does the undergrounding that you're adding apply to this project?
Yes. So just to be clear, I haven't heard from any constituents that they have any trouble with the setback relief or the wall height or anything like that. They've been very clear. They're concerned about the lines that are going to connect the substation to the rest of the grid.
Alrighty, Mr. Attorney, I just have a question about the authority that we have in front of us to be able to add the additional requirements as stated by Councilmember Schubert.
Mayor, Councilmember Schubert, and council members, I think the argument would be that the authority was exceeded in 3.4.6 and could be an exaction because it's unrelated to the requested relief. It far outweighs, and the court would look at that and say that it is greatly exceeded by what the relief requested is.
I'm really concerned. I'm so concerned and torn here because There was an accusation by one of the public hearing speakers that we're just sitting here not caring, with a decision already made, and that can't be further from the truth. I make my decisions on evidence, and my concerns with this particular motion is that we know, if that is your intention, that we're going to go into litigation. My concern is that we're going to spend time and money to get to a point where we're all going to lose. I want to make sure that we look at undergrounding in Tucson as a whole. And for me, it is irresponsible to say that this mayor and council don't care about this. This is something we want. We've been fighting for the the gateway corridors. We've been fighting for the rights of our neighborhoods throughout this process. I mean, I don't know, it's been 7 years. And we've gone to court, we've pushed back on TEP. It concerns me where we are today because mayor and council need to be able to make decisions based on our land use codes and our voter approved general plan. The general plan that we have right now look very, very different. It looks very different than many of the neighborhood and area plans. Why? Because some of these neighborhood and area plans have not been updated in decades. And so I mentioned the mayor and council, I don't know how many years ago it was, moving against the West University neighborhood plan, one piece of it, which was the density and the size of, or the amount of floors that we could add to development next to and in the West University area. And because we did take a position as mayor and council to go against that particular piece of the neighborhood plan, we've been able to develop density in the university, which, by the way, really helped with pushing back against mini dorm development in our neighborhoods. And so it concerns me we would go to court and argue against our ability as a city to push back against maybe antiquated neighborhood plans or area plans. And so I'm not completely convinced that we should move in the direction of the motion. And I'm very torn because I wish we could say, yes, let's underground everything. I think a urban planner and architect spoke at the public hearing. I too am about aesthetics and how our city looks. I'm concerned how this particular case can get us into a rabbit hole and not solve what we want, which is continued undergrounding. Vice Mayor.
Thank you, Mayor. I think that, what I'm sitting with tonight is that the question before us is whether the zoning examiner erred in approving the special exemption and whether this appeal should be granted. And what has been presented to us by the zoning examiner was that he conducted extensive review, held multiple hearings, requested additional information, considered testimony from both supporters and opponents, and ultimately determined that the project complies with the applicable standards for this location. And so I am also concerned about the precedent that we could be establishing in granting this appeal. and that I want to continue to use neighborhood and area plans as important planning tools that help guide our decision-making and express our community values. And I am concerned about using this appeal for undergrounding, kind of putting that together. And like, I think that's the legal, that could have legal ramifications for us, unintended as well, because I think at the end of the day, we all want to see undergrounding throughout the city of Tucson. And I definitely want to, from this conversation, how do we move to updating our UDC so that it mirrors, what the community is asking from us. So I echo your sentiment about feeling torn. I don't feel like this is the mechanism for accomplishing that. But I also do think, what the neighborhoods, what the community is asking for us is to have a more robust citywide policy on undergrounding. So I think that we can accomplish both. Thank you.
Councilmember Dahl?
Yeah, I don't think the city, the community, at least not in this area, is asking for a citywide plan. The community is asking for us to protect them from these overhead lines that will ruin the character of these neighborhoods. I want to say, Roy, you've done a really good job. I'm going to tell you something I told Adam, the attorney from TEP, recently in another matter. You're doing a great job of being a risk-averse advisor. Sometimes we need to take
Thank you,
risks.
Councilman.
And it occurred to me that if we go the way of, we won't do it this time, but we're going to do it citywide soon, then TEP has won the battle, but lost the war. It's going to cost you a lot of money to underground everyone, because I think if we don't do this, there's going to be a movement to force us to do what you're saying we're going to do, and do undergrounding everywhere. So in this case, I think we should do, and recognizing that it is complicated and everybody has a perspective on this, but in talking to my Ward 3 neighbors who are so concerned about these going into an established neighborhood, I think the right thing to do is to pass the motion my colleague has put before us. But I won't be mad at anybody who goes the other way. We will. I count on everybody else.
Thank you, Mayor. Well, I am concerned. I do feel like we do need a comprehensive citywide plan because a lot of the neighborhoods that are the most vulnerable do not have neighborhood plans, and they won't be here at mayor and council meeting past 9 o'clock because of work and other issues. So I do think we need to create a process for a long-term policy based on what's before us today, and I don't feel I can support this proposed modification by Councilmember Schubert. Additionally, within the narrow scope of the special exception, I think we have to have a solid reason to deny. So with all that said, I support approval of the special exception, but would support a long-term process to explore undergrounding citywide.
Are you making that in the form of a substitute motion?
I would like to do a substitute motion to propose a citywide policy for undergrounding citywide.
Already. So that's a
process
motion. Is there
I'll
a
second that.
Okay, there's a motion and a second. And you also asked that we approve the city manager recommendation? Because I heard you would.
Yes.
Okay, so there is a substitute motion and a second. Any discussion on that? Councilmember Lee.
Thank you, Mayor. I just want to confirm that I'm tracking Councilmember Barajas. We are essentially, the motion is to deny the appeal, right? That's the language that I have in my brain, deny the appeal, and then give direction to start a process of exploring a citywide undergrounding policy. Am I tracking, Selena, what you're looking for? Okay, thank you for the clarification.
Any other questions? Councilmember Cunningham.
All right. couple things. One is, I'm still thinking about the actual setback. I'm still back at the 13.5-foot wall. I'm trying to figure out whether or not I thought if you go over 8 feet on a wall in a residential, you're required an additional setback. Was that considered when they did the wall? Yeah, Jim.
Honorable Mayor, Councilmember Cunningham, they picked that number because that would make it consistent with the wall that's already there. And so otherwise, you're going to have this wall that has one height here and one height there. So it was to make it consistent with the university wall that they had.
So the university wall, was the university wall grandfathered in? Does it have a variance? Is it?
Yeah, I'm sure it's to code. So that was the point of that, having that higher wall.
So they went on the continuous wall at 13.5 feet, which is even with the existing university wall.
Did I say that correctly? Yeah, okay.
And is there a required setback when they build that wall?
The setback where they're requesting setbacks, there's only non-residential uses. The side that has a residential, they're setting back 20 feet and putting in a landscape buffer yard there.
And is that in compliance with our existing code, or is that basically the exception piece?
The 20 feet is required, and the landscape buffer yard, I assume that's part of our landscaping code, but I can't say for sure. But it's going to be landscaped too. And that's where they're going to have public art along the wall.
Did they also have, you also said they had to have a setback, the 20-foot setback, I thought that was for a different place. That's not for where the substation is?
It's for the substation, and normally it would be on all sides of the substation, but there are 3 sides of the substation. That's part of it is facing an alleyway by the hospital, and the other parts are by non-residential uses on both sides. So 3 sides are non-residential. It's up against industrial-like uses. Then one side is facing the residents.
So the sides that are not facing residences weren't, it was your interpretation, they weren't subject to the setback requirements?
They got a waiver from that. There's a provision in the special exception that you can ask for a waiver of one of the use-specific standards. And that when we said, okay, that makes sense, but we also want you to do these other things.
I'm assuming that Banner owned those adjacent properties?
I think
where
so.
They got the waiver?
I think so.
So the property owner has to grant the waiver?
No, well, the waiver is granted as part of the special exception.
Unless the property owner protests the waiver,
Right,
which
if
they
they
did.
came here and they were protesting that, but they're not. They're writing a letter of support.
And then on the place that there's an alley, is that our easement or is that a private easement?
The place where there's an alleyway, that's a little road between this property and the hospital, the back of the hospital.
But is it city or is it the hospital owns it?
You know, the hospital.
Dude, all right. Thank you very much.
Alrighty, so we're going to have to vote on the substitute motion, but this is what I'm concerned about. There's so many different things. This is such a complex issue. We've been at it for more than 7 years, and we absolutely understand that the neighbors in this area want to see undergrounding. What I'm concerned about, besides the issues that I've already talked about, is that there's a big question mark about who is going to pay for this, okay? And this conversation happened initially when the issue about undergrounding first happened. I don't know if you all remember, we had put together a really complex and complicated franchise agreement that would find a way to underground this and add it to the ratepayer. And the ratepayer would pay for the undergrounding. The franchise agreement had a lot. But what I heard a lot from the community is that why are we and other people that live in other places that are not going to see the benefit of undergrounding have to pay for that. And so one of the things that we've heard time and time again in our sustainability town halls, especially the Spanish-speaking town halls, was that affordability was a huge issue for them, that they needed relief in terms of pay. And that was one of the main issues that they brought up over and over and over again. I feel as though two things. One, that in whatever way, if we get sued one way or the other, our residents are going to feel the pain of wherever we go, whoever decides to sue us. Two, I'm concerned about that language in the surviving franchise agreement that could possibly make the city of Tucson pay. Again, the residents stand to pay for that. And then the other piece that I have in my mind as well is that it really would cement mayor and councils, or there would be an inability for mayor and council to be able to differentiate with pieces of neighborhood plans that we don't agree with, that possibly have been passed by the voters in the general plan, that two of those don't jive. And that could get us into further unintended consequences that I do not want to get ourselves into, or get any other future mayor and council from being able to have the flexibility to use. This is not about wanting good aesthetics for our neighborhoods in our city. It's about getting to a place where we can put together a code that will be beneficial for everyone. And so I'm going to call the question and go to roll call on the substitute motion.
Councilmember Barajas?
Aye.
Councilmember Cunningham?
Nay.
Councilmember Dahl?
Nay.
Councilmember Lee?
Aye.
Councilmember Schubert?
Nay.
Vice Mayor Santa Cruz?
Aye.
Mayor Romero?
Aye. Substitute motion passes.
So I think the motion was if we are going to have the substitute motion as the main motion. And so now if you would like to pass the substitute motion, you would vote on that.
Okay. We voted on the substitute motion.
So in Robert's Rules of Order, this is treated as an amendment.
Okay.
So you
Okay,
have,
so we
you have,
voted
you have
on
decided,
voting on.
so you had decided if you were substituting the motion. So you voted to substitute the motion.
Now we vote on the substitute motion
If
itself.
there's no further discussion, yes.
To clarify, the substitute motion is to look for a citywide policy and to uphold the zoning examiner's decision and deny the appeal? Is that the motion that we're about to vote on?
That is my understanding,
Okay,
yes.
thank you.
Okay.
Yes.
Roll call.
Councilmember Barajas?
Aye.
Councilmember Cunningham?
Nope.
Councilmember Dahl?
Nay.
Councilmember Lee?
Aye.
Councilmember Schubert?
Nay.
Vice Mayor Santa Cruz?
Aye.
Mayor Romero?
Aye. Substitute motion passes. Okay. And the original motion dies? Yes. Okay. Alrighty. We're closing argument 12. We're going to call to the, no, we're going to budget. Item 8. Okay. So we go on to item 8.
Public hearing, fiscal year 2027 budget as tentatively adopted on May 19, 2027.